You for joining us for today's webinar. My name is Ryan Berg. I'm a benefits consultant at Berg Andonian. Today we are presenting Leave It to Washington, a crash course on the new paid sick and family leave laws presented by Kristen Anger at Summit Law Group. Just a little housekeeping before we get started. If you have any questions, you should see the Q&A box in your Zoom control panel at the bottom of your screen. We'll bring them up during the presentation, and we'll also have time for questions at the end, so feel free to submit your questions there. Before we get started, I'd like to introduce Tracy Zebrick, Director of Client Services at Berg Andonian. Tracy has over 15 years experience in the employee benefits and is responsible for helping our clients accomplish their benefits goals. Tracy?
Oh, thank you, Ryan. As a benefits consultant for Berg Andonian, my job is typically working with clients such as yourself, public entities, financial institutions, schools, unions, and tribes. As anybody knows that's been in the benefits arena for any length of time, it's constantly evolving and placing onus on you, the employer, to take care of all these compliance issues. So as your benefits consultant, it's our job to mitigate your risk. So by providing education such as this seminar and tools that protect you and your employees. So I think this topic is particularly important because employment laws at the federal, state, and local levels can be difficult to differentiate employers, and employers must keep up with all these new regulations. So we're just really pleased to present this to you, and I'm just going to hand it back over to you, Ryan.
Great, thanks, Tracy. Okay, now without further ado, we will turn the time over to Kristen Anger, our presenter today, attorney at Summit Law Group, whose practice encompasses a wide range of labor and employment law matters. I've attended Kristen's presentation on this topic before, and I can say it's content rich. So take notes along the way and use the Q&A feature if you have any questions. Thanks for joining us, Kristen.
Well, thanks for having me, and welcome to everybody who's signed on. The theme for the day or the morning is don't shoot the messenger. These laws are very broad and complex, and I feel like employers are kind of hit with a double whammy. We had the new paid sick leave law go into effect in January of this year, and just as we're still getting our arms around what that requires, we've got the paid family and medical leave coming in 2019 and 2020. And so we're going to take a little time this morning just to walk through certainly the requirements of the paid sick leave law, which we know a little bit more about since it is actually in effect at this point. I'll explain that the paid family and medical leave, there's still some open issues. The statute is in place, but the state is still working on regulations, which will fill in some of the gaps. But we can certainly talk about what we know at this point, what's coming, and then I can kind of point out some of the areas where we're still going to be waiting to hear from the state to get further clarification. So we're going to start with the paid sick leave law. Because I think it's important, even though employers already should be complying with it, we are at least finding that a lot of employers have made an assumption that because they already provide paid sick leave benefits that are more generous than what the new statute requires, they're mistaken in that they don't appreciate always that the law requires that you administer your paid sick leave a little differently. So it's not safe to assume that just because you provide more sick leave that the statute requires, that you're okay, because it affects kind of some of the rules around how you administer that leave entitlement. The slide that you're looking at now is really just a reference slide for those folks who like to be able to actually look up the law and see what it says, or the regulations. So the WAC would be the regulations that apply. This particular law is administered by the Department of Labor and Industries of the state. As we'll talk about, the coming paid family and medical leave will be administered by the Employment Security Department. So two different state departments, and hopefully they'll be talking to each other because there is going to be some overlap here. L&I has a website that has an area of its website that's dedicated to answering questions about this vacation or the sick leave entitlement. So if you have questions, you can look it up. There's some, Q&A, frequently asked questions. They do have some sample forms. I will tell you that I don't necessarily find the forms all that helpful just because they presume that you're starting from scratch. And in reality, most employers already had paid sick leave. So it's a question of amending your existing sick leave policies to comply with the law. But if you are starting from scratch or need some language when we get into things like the verification requirements, you can look to the sample forms on the state website. And there's an explanatory statement as well, as the slide reflects, where the department answered some questions that employers had early on in the rulemaking process. This is a tricky statute in part, again, because it came on top of the fact that most employers already had paid sick leave policies. So there's kind of a fundamental question about how you're going to fit your existing sick leave benefit into this new statutory scheme. And so really you have some options. This slide references policies and CBA. That's a collective bargaining agreement for anyone who has a unionized workforce. So you're kind of taking your existing policy or your existing labor contract and altering it so that you're ensuring compliance with the state law. And there are a couple of options for doing that. One, and I think it's probably the most common, is just to say, okay, we're going to change our sick leave policy, tweak it a little bit to make sure that it follows all of the rules that are required by the statute. For those who have big attendance challenges, there may be some more attractive options. One would be to adopt a separate bank of statutory sick leave. I refer to that as the WPSL. So you could have a separate bank where employees are accruing statutory sick leave, and you only follow these rules when it comes to that particular bank. And when they run out of that bank, you as the employer could apply your own sick leave policy and rules. Because as we'll talk about, there are some frustrations for employers. The state statute really limits an employer's right, for example, to request a doctor's note. So if you've got a sick leave abuser, it can be really challenging to address attendance issues. So employers that have big attendance challenges might elect to say, we want the smallest amount of hours possible to be subject to those statutory rules. So we're going to adopt a separate bank of statutory sick leave and then retain our employer bank. Obviously, some administrative hassle in managing two banks, but the trade-off is that you maybe have a better ability to address attendance issues. The third option is to not necessarily have a totally separate bank, but to designate a portion of your existing sick or PTO bank as statutory sick leave. So you would have, for example, if you granted 10 days or say 2 weeks of sick leave per year, only a portion of that would be designated as statutory sick leave. And once that was used up, you could again begin applying your own rules. So that's kind of a fundamental starting point that employers need to decide. Again, I think the most common is just to modify your existing sick or PTO policy to track the law. And I'll be pointing out in the next several slides kind of the areas where you really need to focus on making those adjustments. In terms of coverage, this paid sick leave law covers, it's very broad, all Washington state employers, public and private. You cannot contract out of this like through a labor agreement, so you can't negotiate an alternative with the blessing of your union. In terms of employee coverage, technically this only applies to non-exempt employees. So your exempt management staff, for example, is not covered by this law. So all non-exempt employees, that includes temporary, seasonal, part-time, your interns who are entitled to minimum wage. It's basically anybody who's entitled to minimum wage, because this law is found in the Minimum Wage Act. If they're truly a volunteer, then they could be excluded. I should note for anybody who is in the city of Seattle or the city of Tacoma, there's an ordinance, paid sick leave ordinance, that covers exempt employees. So you might be picked up by that ordinance, even if you have some exempt employees who are not covered by the state law. So what's the impact of these coverage provisions? Again, because exempt employees are not covered by the law, there's a question, do we want to have then a separate sick leave policy for our exempt versus non-exempt employees? I don't find that many of our clients are doing that. It just creates too much confusion. But one option might be to say that the more onerous portions of the sick leave law would not apply to your exempt employees. For example, again, the verification requirements are the trickiest ones. You can't require a doctor's note until somebody's been out for more than 3 days. So your policy might say something like, we reserve the right to request a doctor's note, provided that if you are a non-exempt employee, we won't do that until you've been out for more than 3 days, et cetera. So that might be a way to exclude the exempt employees from the more onerous portions of the law. Many of our existing sick leave policies that employers had also limited paid sick leave to, for example, full-time employees and part-time employees who worked over a certain threshold of hours. Can't do that anymore. That's one of the areas where you need to revisit your policy and make sure that you are providing at least 1 hour of paid sick leave for 40 hours worked for everybody. So you might have temps, you might have seasonal employees, you might have part-time employees who only work, maybe 20 hours a week or even 15 hours a week. Those people need to accrue paid sick leave, and you have to ensure that they're getting at least 1 hour for every 40 hours worked. Temps that are coming through a temp agency, that's kind of an open question at this point. The regulations don't address how to treat those. We know they're somebody's employee, so you need to work through your temp agency to allocate the responsibility for that. Typically, that could be addressed in the temp agency contract. So just making sure you're not on the hook for that and the temp agency is taking care of that. Okay. Couple of accrual. I want to touch on accrual. As I've already mentioned, employees are entitled to 1 hour of paid sick leave for every 40 hours worked. So if you kind of do the math on that, a typical employee who works 40 hours a week, 52 weeks a year would work 2,080 hours a year. So that translates to about 6.5 days of paid sick leave per year. Again, it's not a huge entitlement, and many employers already provide more than that, but that's what the math works out to. Under the statute, worked means actual hours worked. So if you have somebody who's working a lot of overtime, you got to make sure that they're accruing additional sick leave for every hour they actually work. In contrast, paid time off does not count towards that 40-hour accrual. Excuse me, that this accrual should have started January 1st of 2018. So if you didn't start it then, you can kind of go back and calculate based on how many hours worked somebody should have, how many hours of paid sick leave they have. And at least the statute allows you to have a waiting period for up to 90 days for use. So if you have short-term temp employees, for example, they may not be with you long enough to ever have access to this paid sick leave, right? So they might start accruing from the day they begin working for you, but they can't use it. They won't be around long enough to ever actually use that. The statute does allow front loading for those who don't want to track accrual based on hours worked. You can do a projection of how many hours somebody's expected to work over the course of a year. So again, going back to the full-time employee who's going to work, 2,080 hours a year, you'd say, okay, we project that you will work you will earn 52 hours of paid sick leave over the course of the year. We'll put it in your bank at the beginning of the year, and you can draw on that. If you find that somebody is using, like they're ahead of what they would have accrued, you can't recoup that. Meaning, say you put 52 hours in their bank in January, they immediately go out and have surgery, so they use up all of their accrued sick leave. You can't recoup that out of their pay during active employment. You could, if they resigned February 1st, you could have an agreement with them where you would take that at advance. It's basically a sick leave advance out of their final paycheck. But again, that has to be in writing and signed by the employee. If the employee ends up working more hours than you projected, then you're going to need to true it up. So if somebody ends up working, if they start the year part-time and end up going to full-time, so their accrual would necessarily change, you're going to need to make that adjustment and make sure that as soon as there's an increased entitlement, that you make that adjustment. And as you'll see on these slides, I have references to the WAC, the applicable regulation, if you actually want to track what the regulation says, or you need to explain to an employee, that you can pull up that regulation and show them. So that's what those WAC references are. Another area where employers are going to need to revisit their policies has to do with caps on accrual. Many of our clients in my own office, our prior sick leave policy established a cap. So once an employee got to a certain number of hours, they simply didn't accrue any more paid sick leave. Once you hit, say, 100 hours, you just don't accrue anymore until you draw down that balance. That's not permissible under the state statute as written. What the state does allow you to do is establish a cap on how much can be carried over from one year to the next. And as the slide indicates, the year can be whatever you designate. You know, it could be a calendar year, it could be a fiscal year, whatever. So if your current policy says cap on accrual, easy fix, but it needs to be fixed so that somebody can carry over, and you can limit the carryover to 40 hours, but you have to allow at least a 40-hour carryover. And you can, the statute does allow you to cash out people at the end of each year, as long as, again, you allow them to protect at least 40 hours of paid leave. Okay. Quick reference to PTO programs, because this is I think more and more employers are going to PTO programs where you, instead of having paid sick leave and paid vacation in separate banks, you just put it all in the same bank. It's paid time off. Employees can use it however they want, for sickness, for vacation, whatever. I think these are increasingly popular because there's a perception that employees are less likely to abuse this paid leave benefit if they know their vacation is in the same pot. Whereas with sick leave, they know that, boy, if I don't use these paid days off, they're going to go away, or I'm not going to get the value of them. So this may be an increasingly attractive option for employers. And the statute does allow you to use a PTO plan or program to satisfy the statutory sick leave requirements, as long as your PTO benefit is in writing and it complies with this statute in terms of, you know, the amount of leave accrued, the carryover entitlement, that people can use it for any of the reasons set forth in the statute, that you don't have more onerous notice requirements than what the statute provides, etc. You can, instead of saying all of our PTO hours will be administered consistent with the statute, you could designate just a subset of your PTO hours as complying with the statutory sick leave entitlement. So, for example, if you grant 3 weeks of PTO per year, so 120 hours, you would say, you know, we're also within that 120 hours, the 52 hours that you would accrue over the course of the year will be administered, and will follow the rules as to those 52 hours, will follow the statutory rules. So meaning we won't request a doctor's note, we won't, you can take it in smaller increments, some of the other things, the features of the statute that I'll talk about in the next 20 minutes or so. So you would just need to make sure that you're following those rules with respect to either your full PTO bank or the subset that you elect to designate as statutory sick leave. In terms of the reasons employees can take statutory sick leave, as this slide reflects, it's very, very broad. So this is another area where employers really need to go back to their existing sick leave policies and make sure that they allow employees access to paid sick leave for all of these statutory reasons. So it's the employee's own illness, injury, or health condition, appointments or things for medical diagnosis, preventive medical care. Like if your policy says you need to make your doctor's appointments and dentist appointments outside work hours, you can't do that. Employees have a statutory right to get preventive care during the workday and using paid sick leave. Also allows employees to care for a family member with illness, injury, health, so all the same things to care for a family member. And we have a slide on who family members are for purposes of this statute. Employees can take leave if their place of business or child's school is closed by a public official for a health reason. Any absence covered by the Domestic Violence Leave Act. So an employee who is a victim of domestic violence or is caring for a family member who's a victim of domestic violence, paid sick leave can be used for that purpose as well. As I said, there's a statutory definition of family, and so this slide indicates all of the family members that are covered by the new state law. So employees can take leave to care for a family member with illness, injury, or health condition, or preventive medical appointments. So look at how broad this list is. It includes kids regardless of age, so adult children with a health condition or preventive care, parents including in-laws, spouses, obviously, grandparent, grandchild, siblings. I joke with my brother that, my adult brother, I can take him to get his flu shot and I can use my paid sick leave for that. So it's quite expansive. And again, most existing paid sick leave policies were not drafted this broadly. Child and parent, those concepts include this expansive concept of foster, step, legal guardian, somebody who stands in loco parentis, or kind of in the shoes of a parent, functions as a parent to a child. So that could be like a unmarried couple. They're not married, but where one of them or both of them function as parents to the child of one or the other of them. They both could take paid sick leave to care for that child, including, again, preventive medical care. So I've got the statutory reference here. This is not necessarily a new concept. We already had the Family Care Act in Washington, which allowed employees to use their paid sick leave to care for certain family members, but that was narrower than this new paid sick leave law, in that under the Family Care Act, the family member had to have a serious health condition, something involving incapacity and treatment, versus this paid sick leave law, it's just a health condition. It's also for preventive medical care, so not even the existence of a health condition. Also, we're now covering care for grandchildren and siblings, all right? So that's the broad coverage that you may need to tweak your policy on. Workers' comp, there are questions that come up. What do we do with somebody who's on workers' comp? Many employers don't allow what we refer to as double dipping, meaning that somebody can't use their full sick leave if they're also receiving time loss from the state for the same absence. Some employers say no sick leave in that situation. Others allow supplementation. So we'll allow you to use sick leave to take you up to full pay, since time loss benefits for workers' comp aren't usually for full pay. The state has not issued formal guidance on this point, but questions have been raised. Well, do we have to allow somebody to take sick leave if they're already getting workers' comp benefits? I have traded messages with the state on this, and they are telling me at this point that they don't believe an employer can withhold paid sick leave just because somebody is getting workers' comp benefits. And I have explained to them that that is a sea change for most employers around the state. And they've said, well, we'll take guidance, we'll take input from employers before we issue a formal guidance. So if that is a concern that you have, you may want to reach out to L&I. I know a lot of our clients are saying that's crazy. So we're kind of waiting on guidance from the state on that particular point. I would, at this point, just hold pat if you don't allow double dipping, because I think you are in the vast majority of employers on that point. So I wouldn't probably make a change unless and until we get more formal guidance from the state. Another feature of the paid sick leave law that may affect how you administer your policy, it has to do with usage increments. The statute says that you have to allow usage increments in the smallest amount of time that you use for payroll purposes. So if that's like 1/10 of an hour or 1/6 of an hour, in terms of how you pay people when they clock in and clock out. No more than 1 hour increment. So you can, that is a problem for some of our employer clients. For example, a transit agency. You know, if their employee is 15 minutes late because they had a doctor's appointment, you know, that bus has left the building, that they have now missed kind of a bigger chunk of their shift. And so you can apply to the state for a variance to say, we would like to require that employees use at least 1 hour or at least 2 hours of sick leave, rather than, you know, 10, 15 minutes here and there and there. And the state has to approve that. So you have to show good cause and no harmful effect on your employees. And we've had, you know, for example, the transit clients, that those have been approved. But if you don't have a variance and your existing policy says employees have to use, you know, at least 2 hours at a time of sick leave, that is something that needs to be adjusted going forward under the statute absent the variance. We can require that employees continue to give us notice when they need to use sick leave. And this slide has the rules or the parameters around what can be required. So you can say, if your leave is foreseeable, you're having surgery or you have a doctor's appointment, you can require that your employee give at least 10 days notice or as soon as practicable, as soon as they know the need for leave arises. The catch, though, if the leave is unforeseeable, we can still say you have to call in at least 1 hour before your shift, but we have to say unless it is not practicable to do so. We think that this is going to be an area for abuse. If an employee is going to face discipline for not meeting the call-in requirement, for example, and they can say, well, this is, I didn't realize I wasn't feeling well, but I thought I would be okay. And then I realized kind of as I got in the car that I really wasn't well. So I couldn't call in more than an hour or 2 hours, whatever your rule is. So we're going to see more sick leave abuse, we think, because this is now a statutory right. So if we say, well, we don't believe you, you could have called in 1 hour before, we're going to issue you a warning. The employee could actually go to the Department of Labor and Industries and file a complaint that they're being retaliated against for using sick leave. So be cautious, be probably a little more flexible in administering those calling requirements, because this does create more now of a statutory entitlement to challenge any kind of discipline related to sick leave use. Your notice requirement, if you have one, needs to be set forth in your policy. So if your policy didn't previously address that, that's something that you actually need to do. As I kind of gave you a preview, the verification requirements under the statute are probably one of the biggest headaches for employers. Many policies, existing policies said, we have the right to require a doctor's note, period, or we have the right to require a doctor's note if we have reason to question a particular absence. A beautiful day like today, a Friday, and you get everybody calling in sick. What's going on? Or somebody planned a vacation and then they couldn't get the day off or something, and so suddenly they call in sick. That looks a little suspicious. So the statute has changed that dynamic a little bit, because it says employers cannot ask for a doctor's note unless the absence is more than 3 consecutive work days. That does include partial day absences. So if somebody uses sick leave on 3 consecutive days, even if it's just partial days, you would be able to go ahead and request a doctor's note at that point. If anybody has employees who work unconventional shifts that cross calendar days, the department is saying that the 3-day rule here applies to calendar days. So if you had an employee that worked, 10 p.m. to 8 a.m. or something like that, that would be 2 calendar days. So if they then took another consecutive day off, you could technically require a doctor's note. For those policies that said, we can ask the doctor to provide a medical diagnosis, or we want the doctor's note to be more specific and not just say you're sick, we cannot require that. The employee cannot be required to explain the nature of the health condition, unless the employee is also requesting or seeking FMLA, and then you can use the FMLA form that requires the provider to include medical facts to support the leave request. Employees have to be given at least 10 days to procure that notification as well. So, the rule about, when you come back to work, you need to come back with a doctor's note. That doesn't necessarily fly because they have up to 10 days. This is another area as well where you have to put any kind of verification requirement in your policy. It has to be part of your written policy. Another really wonky feature from my perspective of this paid sick leave law is even in those situations where you require an employee or you have the ability to require an employee to get a doctor's note, the employee can come back and say, well, that would create an unreasonable burden or expense. And they may get off the hook for that verification requirement where they do that. So the employee has to come forward, and we should probably spell this out in our policy to tell you, hey, this leave was for an authorized purpose, and it would create an unreasonable burden or expense because I don't know, the cost of a copay and I can't afford that, or some other kind of unreasonable burden. Under the statute, the employer then has 10 days to either say, okay, never mind, or we'll figure out how to help you with that, whether it's a scheduling adjustment so you can go to the doctor, or we'll share the copay cost, or we'll try to work with you on this, or say, well, we don't think that's an unreasonable burden, you still need to get a doctor's note. At that point, if the parties can't work it out, you have the ability, or the employee has the ability to go to the state, and they can either make a complaint, or L&I will try to navigate the situation, get the parties to some kind of resolution. You have to make sure that you've notified an employee of the right to assert this unreasonable burden or expense defense, basically, before you require the verification. So another kind of policy consideration to think about, right? Again, holler if there are questions. I think that there is a question box and people have the ability to ask questions. I have a question here. So a question is, can this be used by the employee to babysit a grandchild while the parent, daughter, goes to the doctor? That's a good question. I would say no. It's not a child care leave entitlement, but there would be a very easy workaround for the employee to say, well, I'm taking my grandchild to the doctor also. I'm going with them. And how are you going to know that? So because you can take leave to care for a child and a grandchild, if the employee is the grandparent, the employee could take the sick leave to go with her daughter to the doctor, or could take sick leave to take the grandchild to the doctor. Staying home with my grandchild would not be covered unless the employee said, well, my grandchild was ill, had a stuffy nose or a tummy ache, and my daughter couldn't leave him or her alone, and so I need to use my sick leave for that. So it's one of those that the answer is technically no, but I think there's a pretty easy workaround if an employee looks at the statute and just figures out how to frame his or her request. Okay. Another kind of verification issue or a verification issue that we're seeing come up that I just wanted to touch on briefly, and it's a frustration for some of our employers that have very generous leave bank entitlements and that just said, okay, we're just going to have all of our existing sick leave comply with this law. So we've got some clients who have employees with sick leave banks in excess of 500 hours. I mean, these are huge banks. And now the employees are calling in sick once a week, or twice a week. And there's really nothing an employer can do about it. So you get, we've got a couple people now who are kind of close to retirement, and they are just going to start calling in 1 to 2 days a week and work that sick leave balance down, because otherwise it doesn't have any value to them. They don't get it cashed out on their way out the door. And so they just effectively start working part-time and drawing down that sick leave balance. And unfortunately, so the question we're getting is, what can we do about this? And unfortunately, the answer is not much, because you can't require a doctor's note. So as long as they're telling you that they're taking leave for one of those covered purposes, there is not a lot that you can do about it. Now, you still can catch people. If you are suspicious about somebody's use of sick leave and you catch them doing something that is inconsistent with what they told you they were taking leave for, then you could hold them accountable and discipline or even discharge them for dishonesty. It's a little bit tricky because if you just see them around town, well, they might have gone to the drugstore, they might have gone to a medical appointment. But if somebody calls in and says, my back went out, I need to take sick leave today, I can't get out of bed, I can't get in my car, okay, we'll approve you for sick leave. And then you see on Facebook that they posted a picture of them, this is from a real case we had, in a fun run, running and engaged in some very active activity that is inconsistent with not being able to get out of bed, then you could still discipline them. But the kind of daily or weekly chronic, I'm sick and you're not able to catch them, not a whole lot an employer can do to address those situations, which is why, again, some employers are saying we want as few hours as possible subject to these rules, because we sacrifice so much control over our ability to curb abuse. Is there another question?
No.
Okay. So that's what this slide hit, unauthorized use. Yes, we can still, we can first reject, you don't get pay for that day because it wasn't sick leave, and we can potentially discipline. The caveat here, though, is that if you discipline somebody for that, and they think there's an argument that they were covered by the sick leave law, they could actually file a complaint with the Department of Labor and Industries saying that you violated their rights under the law. So we want to, only discipline for sick leave abuse when we get somebody really catch them red-handed doing something. You want to be very comfortable that there is no legitimate use of sick leave. A couple of miscellaneous issues on the paid sick leave. You can have shared leave programs. A lot of you have policies where employees can donate leave for the benefit of a coworker who's going through some kind of catastrophic situation. The catch there is under the statute, it actually says you have to allow the use of shared leave for all of the reasons covered under the sick leave statute. This is frustrating because most donated leave programs are for, like I said, catastrophic kinds of situations, not to take your child or grandchild to the doctor or for those kinds of reasons. So that is one kind of not highly recognized feature of the sick leave law, but we do have to revisit our shared leave programs. There's also some language in the statute about shift swapping. We can't force an employee to find somebody to cover their shift. That's not appropriate. Although we can say, hey, if you find somebody to trade shifts with, you don't have to use your paid sick leave. It just has to be something that's voluntary. Okay, a couple final slides on the paid sick leave statute. Another feature of this is you don't have to, upon separation of an employee, you don't have to reinstate sick leave that was cashed out at 100% of value. So, I'm sorry, I skipped ahead here. Okay, right. So let me first start with the point that you don't have to cash out sick leave. So if you, and most employers don't, or some will provide, some like 10% or 20% of cash out upon separation. But this law does not require you to do that. So you can just say, any unused sick leave is forfeited when you leave. That's perfectly fine. The catch there, though, is if somebody is rehired within 12 months, you have to reinstate the sick leave balance that they had at the time of their separation. With the further caveat that if you limit carryover and you rehire them in the next calendar year, then you would only have to reinstate the 40 hours that they would have been able to carry over had they continued to work for you. And we can't have a new 90-day waiting period for their use if they, if they are rehired within the 12 months. Very briefly, I'll mention this slight point to be mindful of. If you do cash out sick leave upon separation, some employers say, we'll give you 20% of the value of your sick leave bank, for example. If you do that kind of approach, I would urge you to tweak the words just a little bit and say, we will cash out 20% of your sick leave hours. So if you cash out at 100% of value, 20% of their hours, then if they are rehired, you would only have to reinstate the hours that were not cashed out. Versus if I say, you have 20 hours of sick leave, I'll give you 20% of the value of that sick leave, and you rehire them within 12 months, you would have to give them their entire sick leave balance back because you never gave them 100% value of any of the hours in that. So just a very minor tweak, but something to be mindful of if you do sick leave cash outs. Notice requirements, these are another area where you need to make sure that you've done this in compliance with the statute. You have to give employees notice in writing or electronically. So just the L&I poster isn't enough. You have to give them some kind of written document that tells them of their statutory right to paid sick leave, what their rate of accrual is, what the reasons are that they can take leave, and that there will be no retaliation for using leave. This is a new requirement going forward for anybody who is hired. You have to give this notice upon hire, and there's a sample form on the LNI website that you can use as a starting point. For our existing employees, we were supposed to have given this notification by March 1st of 2018. Just one quick comment on the state's sample form. It may be a good starting point, but if you're using your existing sick leave or PTO policy, you're going to need to modify that to say, you know, you have this new entitlement under state law to paid sick leave. We're relying on our existing sick leave or PTO bank to comply with the law, but we want to give you this notification to ensure that you understand you can take your existing sick leave for any of these purposes and there will be no retaliation. So just something that kind of conveys, instead of just slapping out the state form, because I think that might cause people to believe, oh, this is on top of what I already get. So we want to just make sure we're explaining that how this is merging with our existing sick leave benefit. Couple more notice requirements. This just has to do with how to convey or what to convey to employees in terms of what their entitlement is, their accrual. So every month we have to be telling folks that how much sick leave has accrued, how much they've used, and how much is available for their use. And so if you can just modify your existing payroll records or payroll notifications to convey that information, you should be fine. If you have a policy or a labor agreement, the statute says if you have requirements as to any of these things, reasonable notice that employees have to provide in advance of an absence, verification, shared leave, or front loading, those need to be in writing and included in your policy. And the statute does say it's okay to have different policies for different work groups. So some employers that never provided, for example, paid sick leave for temps or part-time employees under a certain hour threshold, you might have a separate policy that just gives them 1 hour for every 40 hours worked and follows the statute instead of kind of incorporating them into a richer paid leave benefit that you have for full-time employees. And very, very important to make sure your supervisors understand no retaliation for using paid sick leave. That is going to be a new cause of action that somebody can sue us for if we interfere with or discipline somebody for using this statutory sick leave. So the statute says we can't interfere with the use. Can't take adverse action against an employee, so denying them a promotion, disciplining them, reducing their work hours, denying an attendance-driven production bonus because they use paid sick leave. So some of you may have sick leave incentives. If you don't use more than X hours of sick leave in a year, you get this monetary bonus. That's not appropriate anymore under the statute because now you're penalizing somebody. So you would have to exclude your paid sick leave usage from that. So even though they use paid sick leave, if you have an attendance bonus, you have to kind of ignore that, and they might still be entitled to the bonus in that situation. All right. A little further comment on the no retaliation provision, things to look at in your existing policies or labor agreements. If you have a kind of a no-fault attendance policy where you don't care why somebody's out, it's just that they have so many occurrences they get disciplined, that's a problem. We can't count any absence covered by paid sick leave as occurrences for purposes of any kind of disciplinary. We need to make sure our managers and supervisors are not referencing sick leave usage in performance evaluations and maybe criticizing somebody's reliability or any kind of negative consequence arising from sick leave, or expressing frustration, about somebody being out when it's a form of statutory sick leave. And again, I mentioned the attendance bonus. Essentially the message is treat this like FMLA. It is protected and there can't be any negative consequences arising from the use, all right? Sick leave cash outs are permissible if you do that maybe annually or at the end of the year or at the time of somebody separates. That is okay. The only catch with kind of the annual cash outs is that you still have to ensure that somebody can carry over at least 40 hours of sick leave. So we couldn't have a policy, for example, that says we cash out all unused sick leave at the end of each year. So you start the new year with nothing in the bank. That would be inappropriate because we have to allow the 40-hour carryover. So I have just a slide 2 here on just a compliance checklist to make sure that your existing policies, these are the pieces to look at in your policies to make sure that they're compliant, that we're covering all of these people who may not have been covered in the past, including temps, seasonal, and part-time employees, that our sick leave policy is expanded in terms of the covered reasons for which somebody can take sick leave. If we have got a cap, we need to convert it to a carryover limitation instead of a cap on accrual. You may need to change verification requirements if you have, if your existing policy allows you to require a doctor's note sooner than being absent more than 3 days. If you have kind of usage increments inconsistent with the statute, you're going to need to tweak that. And then eliminating penalties, like I just mentioned. Some other considerations, obviously, if you've got a labor union on the scene, you're going to have to bargain with them about any changes that you make. It's obviously a legal necessity to begin administering the law consistent with, or administering your sick leave policy consistent with the law, but the way you do it, as we've talked about, you do have some choices about how you do it, so that may be subject to bargaining. Coordinating with payroll to make sure that you are tracking and providing the notifications appropriately. Got some other ones here. Training your supervisors to make sure they understand the no retaliation. Including your sick leave notice when people are hired. That should be part of your hiring packet, and making sure that you've provided notice to your existing employees. And then again, making sure your payroll notices are compliant in terms of educating people about how much available sick leave they have and how much they've used. Okay, so we have another question here. Are there any special considerations for a probationary employee who has used all available sick leave? If we desire to exercise our right to terminate, what are the risks? That's a good question. So a probationary employee is typically at will, so you shouldn't really need to have a justification. If once they've used up their sick leave, now they may not have had access to it because if they're in their first 90 days and you have a 90-day wait period, they may not even have access to it at that point. But let's say that you don't have a wait period, they've used up their sick leave, they're continuing to have attendance issues. At that point, the paid sick leave lies out of the picture. You would not have to worry about it. It's not like somebody could come back and say, well, I'm now out of sick leave, and so you're clearly retaliating against me for having used it. No, our focus is the fact that you're continuing to be absent beyond your statutory entitlement. So we didn't have a problem when you had leave in the bank. The one question that I would want to discuss with an employer in this situation is, why is this individual absent? Is there a health issue that might be a disability, and should we be talking about reasonable accommodation of a disability? So I would want to ensure that somebody in that particular situation doesn't have a disability, or if they do, so they have some chronic health issue, okay, we need to go through the process for discussing whether we can accommodate that or not. But that would be the only concern that I would have with respect to a probationary employee in that situation. Okay. Couple of miscellaneous issues that I'll just touch on. These are kind of questions that we get on a fairly frequent basis. Some of your policies or labor agreements say that in order to get holiday pay, you have to be working the day before and the day after the holiday. You have to be at work. Can we do that if somebody calls in? What if they call in sick on the day adjacent to a holiday? Our advice has been that is penalizing somebody for using protected sick leave. So I would be concerned about that particular practice. We don't have guidance on it, but again, I think that is denying somebody compensation for an exercise of their statutory rights. So I would be concerned about a policy that did that. How about an employee who gets double pay if they're required to work on Sunday and then they call in sick on the Sunday? I posed this particular question because the statute technically says you don't have to pay holiday pay and premiums, but the state has told us that you have to pay them whatever they would have earned had they worked on that day. So if there's a shift differential that they would have been entitled to, like this, you double pay on a Sunday, you're going to need to basically replicate what they would have earned on that day had they worked. And then another question that I've gotten a number of times is, employers who counsel or even discipline employees who burn, kind of churn and earn and burn. So the moment they have any hours come on into their bank, they call in sick. Can we counsel people? Can we discipline them for that? Because the idea is that they should try to build up a bank. I do not think you should be doing that. The only thing I think you could do is sit down with them and say, I'm concerned that because you use it as soon as it's available, you really don't have any cushion, which causes me to have concern that you will go into a leave without pay status. And at that point, they could be disciplined. So, kind of just counseling them, not in a disciplinary way, but just kind of educating them about it would be in your interest to kind of try to build up a bank because stuff comes up. We get sick from time to time, and you just want to make sure that you don't go into a leave without pay status. So that is all I had on the paid sick leave. Still, if there are questions, feel free to submit those. But otherwise, I'm going to shift gears and talk about this new paid family medical leave. As I indicated, we know a lot less about this one. So we're going to kind of take a high-level approach looking at what's coming. But the gist of this new law is that it's basically a form of insurance for employees, almost like unemployment, that's going to provide partial wage replacement while employee is on leave for covered family and medical reasons. So we'll break that down a little bit. And there are two aspects of the law. One is protected leave, so it's kind of like FMLA, it'll look like FMLA, but they also can apply to the state for compensation while they're on leave, and that's this insurance system that's going to go into place over the course of the next couple of years. In terms of the timeline, the regulations are still being developed. The premiums that employers are going to have to start paying, those are going to kick in January 1 of next year, so January 1, 2019. No benefit entitlements, though, are going to be available to employees until January 1st of 2020. So the premiums are going to kick in a full year before anybody can actually start taking that leave. For those of you who have policies tied to the Washington Family Medical Leave Act, so that's our state version of the FMLA, that leave is going to go away at the end of 2019, and so this statute would be replacing that, okay? Sorry, I got behind on a slide. So that slide kind of shows the timeline that I was just talking about. If you have, I don't think we have too many people here with labor unions on site, but if you have a collective bargaining agreement that was in effect as of last October and has remained in effect since that date, hasn't been reopened in any way, then you don't have to begin complying with this law in any way until your labor agreement expires. That's the only kind of way around compliance with this particular new law. Except for those grandfathered CBAs, you cannot contract around this with your labor union. Say, well, we want to have our own system. As I'm going to talk about, you can adopt a voluntary plan, but it really has to look and smell just like what this law provides. So we can't say we're going to do something totally different and negotiate it with your union. In terms of who's covered, very, very broad coverage of employers, public and private, regardless of size. There are some special features for smaller employers. If you have fewer than 50 employees, you don't have to grant protected leave. So your employees don't necessarily have the right to take family and medical leave because you're not covered by FMLA. It kind of mirrors the FMLA. And you don't have to pay the employer portion of the premium, and I'll talk about what that is. So your employees are going to pay into the system, and you have to collect that via payroll deductions, and they can apply to the state to get paid time off and the monetary benefit, but you don't necessarily have to grant them leave. For 150 employers with fewer than 150 and those small employers under 50 who elect to pay into the system, there are grants available. So you can get like a $3,000 grant, for example, if you have to hire a temp for more than 7 days. There are limits on how many times you can do that, but you can do it, I think it's up to 10 times a year. Or if you can apply for up to $1,000 for things like increased overtime costs associated with an employee who took family leave. So a little bit of support for smaller employers to minimize the burden and the costs of compliance with the system. Employees, very, very broad. So unlike the paid sick leave law, exempt employees are going to be covered by this. In terms of their eligibility, they have to have worked at least 820 hours for any covered employer, so any state employer. So that's different than FMLA, right? I mean, for FMLA, they have to have worked for you for at least a year. This, in this particular law says they have to work for some employer within, 800 up to 820 hours in the first 4 of the last 5 full calendar quarters. So a complicated system. Again, it looks just like unemployment benefits in terms of eligibility. They have to have just paid into the system long enough. Those employees who don't meet eligibility for FMLA, so they haven't worked for you for at least 12 months, they technically don't get the protected time off. So they can apply for paid leave benefits. You don't necessarily have to grant them the time off. It wouldn't be protected under the statute. So that's the difference there. In terms of the premiums, I encourage you to start kind of doing the math here and crunching numbers to budget for this going into 2019. The premium is going to be equal to 0.4% of employee wages up to the Social Security cap, which is for 2018, it's like $128,400. So any wages below that cap would be subject to this premium at 0.4%. And then as you can see, that is split between the employer and the employee. There's some formulas here, 1/3 of the premium is for family leave, and you can tag the employee for 100% of that. The kind of big percentage to focus on is 37%. So if you, that's the employer's share of the total premium. So if you take somebody who's earning $50,000 a year, the sharing works out that you would be responsible for 37% of that premium. So total annual premium would be $200. Your share of that would be $73.33. And the employee would have to pick up the rest through payroll deductions. The statute says employers may elect to cover the full premium. So you can do that. I don't think most employers are, unless you have a union on site and they demand to bargain and persuade you to pay the full premium. So just something to be mindful of. Covered reasons for leave. They're both medical and family leave. Medical leave is going to be just like the FMLA definition, so leave needed due to the employee's own serious health condition or to care for a family member with a serious health condition. The list of family members is a little broader than the FMLA because now we have grandchild, grandparent, sibling. Bonding is also covered, so that's the family leave, after somebody, an employee has a new child placed by adoption or foster child or childbirth. And then also covered the military qualifying exigencies that are under the FMLA. That would also be available for benefits under this law. The duration of the medical leave is similar to FMLA, so it's 12 weeks during a consecutive 52-week period. If the employee has a pregnancy-related serious health condition, that expands to 14 weeks. The family leave is 12 weeks, so that's that bonding time. They would have 12 weeks, so again, just like the FMLA. Combined total of 16 weeks of family and medical leave, going up to 18 weeks if it was a pregnancy-related serious health condition. Okay. Generally speaking, this leave is presumed to be concurrent with FMLA. So you don't have to, say, okay, first you'll take the state leave and then you'll have your 12 weeks of FMLA. It should run concurrently with FMLA. The statute says it is in addition to pregnancy childbirth disability leave. So we have a state statute in Washington that grants a female who is disabled by pregnancy or childbirth protected time off for the period of disability. Now, the period of disability, somebody should be able to apply for the state benefit. So our understanding of what this means is that if somebody continues to be disabled by pregnancy or childbirth for more than the leave entitlement that's under this state law, they would be entitled to continue to have protected leave for that period, even though they may have exhausted the financial benefit available to them. This leave is also in addition to leave that employee has while they're receiving workers' comp benefits. So that's going to be a little tricky, and I will touch on the workers' comp interaction again in just a moment here. The statute, there's a lack of clarity about intermittent leave. As you know, if you have FMLA eligible employees, FMLA allows people to take leave intermittently, maybe reducing a work schedule, or, they get flare-ups of a condition, so it's, several days a month, something like that. This statute doesn't, I word searched it, there's no reference to intermittent leave, but there are a variety of indications that intermittent leave is contemplated. For example, statute says the minimum claim that somebody can make for a paid benefit is for 8 hours. So that suggests that, somebody has a chronic condition, they can be taking leave intermittently and they can get the pay benefit as long as there's at least an 8-hour benefit. What I think is tricky in this, and stay tuned on this, FMLA does not allow intermittent leave for bonding time. So after somebody has a new baby and maybe the dad wants to take 12 weeks of FMLA, we can say you have to take that all at once. You can't take 3 days here and 4 days there and 2 weeks there over the course of the year. It has to be taken in a single block. That's FMLA. So we've got this new law that doesn't mention FMLA. And so it also doesn't include the FMLA language that intermittent leave for bonding must be taken in a single block of time. We hope that the Employment Security Department will issue a regulation to make it consistent with FMLA. Otherwise, we're going to have a headache on our hands, I think, because that would be inconsistent with FMLA. The leave entitlement runs out after 12 months following birth or placement if the leave is for bonding. The other kinds, it would expire 12 months after the date the employee filed the application for benefits. And so let's talk about this benefit administration briefly. The good news is the state takes care of all of the benefit administration. We're going to have notices that we have to provide employees, and those are going to be coming out from the state. But the state processes the benefit claims, just like with unemployment. So we just tell somebody, here's your right, and then they go off and file a claim, and the Employment Security Department does all the math. The employee is going to have to tell us that they're taking leave, and we may have an obligation to grant them protected time off, but the financial aspect of this is going to be administered by the state. And there's a 7-day waiting period for benefits through the state. What's the benefit amount? The actual benefit is a percentage of, this is a complicated slide, and I'm going to tell you right out. The good news is you don't have to do this math again because the state is doing it, but you can see there's this kind of complicated formula that is tied to the employee's average weekly wage in the highest 2 quarters of the qualifying period, which is that 4 or 5 month period looking backwards. So the state would calculate what this is. For our purposes, just kind of rule of thumb, the maximum that anybody is going to be able to get is $1,000. That's going to be adjusted annually because it's tied to the average weekly wage. And then there's a weekly minimum, which is the lesser of $100 for the employee's actual weekly wage. So that's kind of what employees are going to get, this new entitlement that they will have to compensation. So be mindful of the fact that employees who historically maybe didn't take as much leave as they were entitled to under the FMLA because they couldn't afford to, you're going to have more people taking leave because they can afford to. They have some compensation that would be coming to them that encourages them or permits them to stay out longer. So that's just a consideration in addition to thinking about the premium and budgeting for that. Thinking about if you're already very leanly staffed, are we going to have coverage issues because employees are going to have more access to paid time off. Some of the biggest questions remaining that we don't know about yet, and we're waiting on regulations, relate to how this new paid leave entitlement is going to interact with other leave entitlements, both on the statutory side and employer's own leave benefits. We do know that an employee will not be eligible to receive the paid benefit through the state if they're already receiving workers' comp benefits. So you can't kind of double dip in that respect. Also cannot get unemployment benefits and paid family leave at the same time. And health insurance, in terms of when we provide health insurance to an employee, we have to keep their coverage intact only if they're eligible for FMLA. Otherwise, if they were on an extended absence, they would maybe go on COBRA, for example, unless they were FMLA eligible. The bigger area of mystery relates to how this paid leave entitlement interacts with, for example, sick leave and other forms of accrued leave. The statute has what I consider to be some really confusing language. It says the employer may allow an employee to choose whether to use accrued vacation, sick, or PTO, or not take such leave and receive paid family medical leave. So it looks like, okay, you allow them to choose. I think it should say the employer may require the employee to choose one or the other, but it says you may allow them to choose whether to take paid sick leave or apply for state benefits. So the question that is begged in my mind is, well, what if you don't allow them to choose? Does that mean they get both? It's not entirely clear to me. We've had some discussions with the state, and it sounds like what they are envisioning is that an employee would be entitled to supplement this statutory benefit with any accrued leave. Obviously, the wording could have been a lot clearer, but we're expecting that that's what we're going to see when the statute comes out. So stay tuned on that particular issue. Final slide here on the substance is your ability to opt out. So there's a whole set of statutes, statutory provisions in this act that allows an employer to opt out of the state system. I'm not sure it's going to be a real popular option because you have to essentially replicate the benefit that your employees, your employees would be eligible for under the state system. So you would have to apply to the state. They give you approval. They would vet your plan, and you can opt out of family leave or medical leave or both. So you could only participate in half of the benefit scheme. But your plan would have to be vetted and blessed by the state before you would be able to do that. And in that case, you wouldn't have to pay premiums. You wouldn't have to collect premiums from your employees. They wouldn't be eligible because you are providing a comparable benefit. So I'm not sure, given the complexity of this system, that that's going to be a very attractive option for employers, but it is something to consider. I mean, for example, a lot of employers already provide short and long-term disability policies. Okay, so you have to think about, well, how would we integrate our existing disability policies with this? Do we want to get rid of our STD and LTD plans? How are we going to reconcile these? It's just that a lot of the existing disability plans don't get into things like family leave. So they're not going to be entirely easy to replace via an insurance policy. Although, there may be kind of plans coming in to fill in and would be able to replicate what the state is doing in a private capacity. So that's something that remains to be seen, whether that's going to be a popular option. I think in terms of the action items, just to wrap up on this particular topic, the action items under the statutory family and medical leave are to immediately, I think in the short term, figure out the budget. What is this going to cost us in terms of additional premiums, so that we can budget for those additional costs going into 2019. Certainly, if you have represented employees, you may need to alert the union to the fact that you're going to have to begin making payroll deductions on January 1, 2019. They may request to bargain that because it's not necessarily absolutely required that you deduct the premiums from the payroll, because the employers have the option of picking up the whole premium. So I would at least notify them that we intend to begin making payroll deductions consistent with the law, and then see if they request bargaining. If they don't, then you can just proceed. Then next kind of action item doesn't kick in until January 1 of 2019. You're going to have to start making the payroll deductions as of the first payroll in 2019, and then remitting the quarterly payments, premiums to the Department of Employment Security. Once the regulations are out, I'm cautioning employers not to try to start making policy changes at this point or figuring out what our policy is going to look like, because we still don't have the regulations, even in draft form, that get into how this benefit interacts with a lot of other existing paid leave that employees already offer. So I wouldn't kind of rush in and try to figure out what you're going to do exactly. I'm expecting that we'll at least see the draft regulations in early 2019, and so at that point, I think you can start thinking about, okay, how do we fit these together? Do we still want to have an STD plan? For example, we offer paid parental leave of 6 weeks. Do we want to keep that? How are we going to fit that in with this new entitlement? So you can start reevaluating at that point what existing benefit plans you offer, and whether you want to scale those back a little bit in recognition that employees are going to have access to this additional compensation through the state system. Because if you keep all of your existing rich benefit offerings and also employees have access to this state, it's going to be, and there's going to be a lot of absenteeism, basically, because people can afford it. So just kind of revisiting or thinking in the big picture how we're going to try to fit these, and do we want to make some adjustments in the things that we offer voluntarily to our employees to kind of achieve the same overall level of support, but not creating this whole additional paid leave entitlement on top of something that we already are doing. So that's all the material that I had for folks. If there are any other questions, I'm happy to answer them. Okay, we've got a question. Any idea if we will need to report state benefits used by the employee on their W-2? Ooh, that's a good question. I can't imagine how you would have to report that on the W-2, because the money's not coming to you. It's going to be going directly to the employee. But God, that's a good question. I haven't seen any guidance on that yet, but my assumption is that no, because it is a transaction. The financial piece is a transaction that is between the employee and the state. It is not routed through the employer, so it's not coming to you to then disperse to your employee. It's income like third-party sick leave. Yeah, I think that's how I would think of it. I don't know, actually. I don't know the answer to that definitively. So that my answer, I guess, is just an assumption just based on kind of thinking about it logically, but I don't know the answer to that yet. Okay. Any other questions? If not, thanks for listening, and I appreciate the ability to chat with you all this morning, and I'll turn it back to Ryan.
All right, thanks, Kristen. It was a great presentation, very relevant topic to most of our clients. So everyone that attended the seminar, thanks for listening. If you have any further questions, feel free to shoot me an email. My email is on the second slide of this presentation if you don't have it elsewhere. Thanks so much for attending, and that concludes our webinar. Thank you.